Delighted today to be joined by Mr. Keith Kelliher. Keith, I was doing a bit of research on your first of all, welcome to the Live Cost Construction Experience. Yeah, great to have you here. And I was looking through your background, quantity surveyor and principal of Kelliher and Associates, arbitrator, accredited mediator, adjudicator, part-time lecturer, and also well known for your workshop, the CIF. There's a fair bit going on there. How do you manage that, first of all?
Good diary keeping is really a lot of it intermingles quite well, which makes it easier. And I suppose, if nothing else, it kind of offers a variety of work that makes it a lot easier to kind of keep going every day. Quantity surveying can be a lot of the same thing over and over and over, and different projects, and you get different things to look at on that, but a lot of the mechanics behind quantity surveying and the process you go to can be the same on every building. So like, you'll have a lot of people who will kind of say, like, I've done a motorway, I don't want to do another one because it's the same stuff. And so having other avenues to spend time at during your working day just
makes sense.
Is enjoyable. And I suppose from the downturn, that was a necessity, I suppose, more so than a choice to do certain things.
Move into. So I mean, I have to give you credit first of all, because I got back from Australia, and I suppose I looked at who has influence around the industry. It's not that big of an industry, and I've sort of reached out to as many people as I could. Loads of people didn't come back to me. You were one of the ones that said you would come back to me, and we sat down and we had a coffee, and you helped me out a lot. So first of all, I need to give you credit for that. But I walked away from that coffee after you gave me about a 10-15 minute intro into the Construction Contracts Act and what it was, and I felt, Jesus, I don't know anything about this, right? But then what the biggest highlight was, when I went out and started speaking to my customers about it, they didn't either. Where was your sort of first contact with that act?
Since the outset, like, I suppose, to take it back, like I've been involved in the dispute side. The very first job I ever worked on was the M50 motorway from Tala to Dundrum. For BAM, or Ascon as they were at the time, BAM contracting as they are now, and I was there for 3-4 years on that job, and that job ended up in conciliation, which is a method of resolving disputes, and that was my very first job. And that conciliation, I think we were on it for about a year, I'd say, just producing paper. So first job ever, dispute, and I suppose I've never left that world. So when the downturn came, and even before the downturn, there was kind of a lot of kind of rumblings in the industry that we needed a better way to fix our disputes, and we needed, particularly in the subcontract community, there was a lot of push to protection of subcontractors and systems to allow for the flow of money down through the system. So that was going on before the downturn, but I think the downturn 2007 and into 2008 kind of crystallized the need for like, main contractors were going bust and bringing 40 or 50 family businesses with them. At the core of a lot of this, you found that a company might be a relatively small company, but they had wound up a debt with one particular main contractor over 5 or 6 jobs. That debt was wound into the next job too. Suddenly, like, the figures that were being quoted, that companies were being owed $1 million, $2 million, $5 million, and these are small businesses. And this debt just constantly being round up to the next. I hear, we'll get it on you in the next job, the next job. And you multiply that across the 10, 15 big contractors who went bust. And there was 40, 50 family businesses went with each one of them going. So there's a big discussion started around 2007, and I know Ciaran Keith was high up in that. Ciaran had smart homes at the time, and it's on record, a lot of debt built up with developers and contractors. And so a discussion started. He eventually ended up sitting down with Fergal Quinn, who's unfortunately passed away, but Fergal took the kind of the lead on, saw the need for this piece of legislation. Being an independent senator probably helped. He was able to kind of like bring this legislation, I suppose, without the political kind of football aspect, if it was under a party.
What was the main driver, Keith? Like, was it down to payments?
It was a lack of a payment system,
right?
But a way of forcing money down through the system. In a way that we didn't have. Really, that's like, cash being the lifeblood of every single business. You'll have it yourself, particularly in early days in businesses. So the old system was very kind of like aggressive in terms of you had to be aggressive to get the money to flow. Not with every contractor. There is contractors out there, main contractors in this industry that, you know, most subcontractors would love to work for tomorrow. They don't have issues, but as an industry wide, we had lots of problems with the funnel of money flowing from top to bottom. Okay, and when the money stopped flowing, the inability for there to be a system to make it flow again, you know, so the angiogram on the heart, you know, that kind of like, how can we unblock this?
And was it put in place as a protection mechanism on the subbies part, or was it just to put a process in place that we should all be playing by these rules?
It was pushed by the subcontract community because they bore the brunt. You know, like at the end of the day, Ciaran Keith was a subcontractor. He pushed it. The legislation was drafted, but like the CIF and others would have fed into that, and it became an overall piece of legislation for the industry, not just for subcontractors. But when you read it and when you like look at the case laws and stuff that are in the UK around similar legislation, it's very much that main contractor subcontractor divide. And it was mainly pushed by subcontractors, but it does have the exact same protections for main contractors, you know, bar one slight difference, you know. But
is our model replicating the UK model?
It's not replicating. Like the UK model, the legislation is 100 pages, ours is 13. Right. So it's not an exact replica. The process is the same, but but our system is not. It's not an identical. We use some different terminology, but the overall model, let's say, would be the same.
And sort of at a high level, what does it entail? What does it mean as an act?
Well, there's two parts to it. Okay, so the biggest difficulty with, I suppose, the adjudication process is that you can only go to adjudication if you have what we call a crystallized dispute. Okay, now people will think, and in many cases, you know, a subcontractor will be around with a main contractor in the middle of a job that subcontractor will be looking for 50 grand and the main contractor will be paying them 30. Now, in the current system, it will be viewed that you have a dispute there over 20 grand. But in our current system, we have, and even many of your clients and people who've never heard of construction contract, they operate in an interim valuation process. So you send in an interim valuation and the main contractor pays you what's called on account. Okay, so you're looking for 50 grand, I'm going to pay you 30. We'll sort out the 20 near the end of the job. There was never a crystallized dispute because it was all on account, it was all interim valuations, and you know, and the difficulty with that would be that if you had that 20 grand theoretical dispute day one, by day 400, that 20 grand could be 200 grand because that dispute between you could have a continuing effect. So the Construction Contracts Act, when it came in, was kind of two-front. One, that it had a method of formalising a dispute on a cycle. So on a payment cycle, there would be a way that both parties would know they're in dispute, and that would crystallise. And that's one whole part of the Act that a lot of people don't hear about, and that's the basis of the seminar I run with the CIF, is around this whole idea of there now being a payment process and how you follow that process to get paid. And that's kind of what I say, and anyone's been to any seminars will hear me talking about, that's coming in the front door. You come in the front door, you seek payment in the right way, the other side have to come back to you and explain to you why you're not getting paid, and they have a set time period to do that. And if they don't comply with that time period, you're entitled to all the money you look for. Okay? If they come back to you and explain to you why you're not getting paid, you then can negotiate with them, or you can give them the information they need to justify your payment. So it opens that communication. And
just to jump in on that point, Keith, is there fear if I'm on the subby side, for example, and we're at the start of a project, and you know, let's say we use your example, 50 grand claim in, he's going to pay me 30 grand, and I'm going to go after the other 20 because I needed to pay the lads. Is there a fear there we've got another 12 to 18 months left in this project and I'm going to completely destroy the relationship, so I won't bother, I'll try and cash flow that somewhere else?
There is that fear, but I suppose it's where the Construction Contracts Act is aimed at, is in that initial part about the payment, is that it provides a kind of roadmap where you know why that 20 grand exists. That was one of the biggest issues that that we would have had in the industry for years, and still do today, if you're not using the system, is the lack of communication between the main contractor and subcontractor as to why they're not getting paid. So if you don't know why you're not getting paid the €20,000, it makes it very difficult for you to resolve that issue between you. Okay, so the Construction Contracts Act places a requirement on them. So you now are in a scenario where you know why you're not being paid. Okay, and what that does for you then is that it crystallises that 20 grand dispute. But it also lets you know, right, well, is this something that we need resolved today, or is it just something that's going to come out in the wash? Like, is it a dispute over you saying that I'm 50% finished the wall and I'm saying I'm 60? Well, next month that'll have washed out because I'll have progressed. Yeah. But if it's an issue like where it's a variation to the job, and you know, as a subcontractor I'm claiming a variation, and you're the main contractor and you're saying no, I don't agree that this is a variation, that has to be resolved. And if you need the cash, you need it resolved today. Yeah. If that impacts that relationship, that's just a commercial thing. Like, at the end of the day, is the relationship worth more to you than the 200 grand hole you'll find yourself in 6 months?
And what is a general time frame? So if let's say we do have that dispute, it's a 20 grand hole that we're disputing over. I mean, if I want to go and now chase that, what does that process look like?
And this is adjudication. So this was the second part of the act. So the first part was about crystallising the dispute. Yeah. So both parties knew they had an issue. The second part of the act was the introduction of adjudication into Ireland. Okay, it's the first time in construction. It is in other areas, but construction is what we're talking about. And it's purely for payment disputes. And how you start it is you issue what's called a notice of intention. So in simple terms, you write a letter. There's certain requirements of the letter, but you write a letter to the other side and saying, look, we're in dispute. We're going to refer this to adjudication, and basically here's our notice letting you know we're doing that. Okay. Now, as I said, there's technicalities, but high level. You then have to wait 5 days. You have to let a 5-day window pass before you can do anything. The reason for that is to kind of get the parties maybe in the 5 days to come together and see can they resolve it without you taking the next step, or even use the 5 days to agree between you who the adjudicator may be. Okay. On day 6, if nothing has happened, you can then apply to a panel, and it's a panel held under the Department of Jobs, Enterprise and Employment, or whatever that department is currently known as, the one that changes name on a regular basis. They have a panel of 31 people, but one of them is the chair, Dr. Neil Bunny, and then he's the chair of the panel, so he can select one from 30. You apply to the panel, one of those 30 are selected. Okay. That will take on average, it's free. There's no fee, you just literally fill in an online form, send in the information. Between roughly 5 to 7 days later, they will write back to you and say Joe Bloggs is appointed. Okay. The day you receive that letter and the date you receive that letter, you have a maximum of 7 days then to lodge what we call the banker's box. So you lodge your claim, which is called a referral document. So in the intervening period, you have to pull together your claim. So this is the document that you're going to basically submit that proves you're owed the money. Yeah. Okay. Because adjudication is quick, so you may never meet the adjudicator.
What does that look like here? As in, like, what sort of documents are we talking? Are we talking
a story? It's a narrative around the background to the story, but also like what it is you're claiming and proving. So like, what's the 20 grand about?
So quotes, contracts, emails, whatever you have.
Proving you did it. It could be buried in the ground. So proving if they're saying you never did this item, you have photographs proving that you did. You know, any documentation. I use the analogy that it's a document that you're submitting to the parish priest. Right. And if the parish priest doesn't understand it from reading your document isn't good enough. And it's that type of document. Now, our documents, like we've done this many times at this stage, and like it could be 30 pages, it could be 1,000, depending on the scale of the dispute between you. Okay, but you have 7 days to submit that document, and the day you submit that document is day 1 of a 28-day process, and on day 28, the adjudicator will issue a decision. It can be extended, but in theory, that's the process. So it's quite quick.
It is quick,
You know, and particularly if that happens in the middle of a job, you're getting an answer. Yeah. So that 20 grand doesn't become 200 grand because both parties have their answer. Yeah. And they can mitigate. So like even as I say to clients, even if you lose, you've lost early. Yeah. You're not losing a 200 grand. You're losing a 20 grand, and you can mitigate
Yeah, very true.
That issue.
Yeah, the worst thing we can do is bury the head in the sand and say let's keep going here. We'll figure it out. Is the worst thing we can say. So I mean, documenting, processing, having all
records. Like there is no like we've moved on so far. Like our industry is now so paper driven. But bizarrely, the commercial side of our businesses are the worst kind of managed when it comes to paper. Like I would have people come to me and they can give me like 6,000 pages and records of health and safety that they have signed on a job, and they will have no records whatsoever of being asked to spend £500,000 on variations.
Yeah, I was just on site yesterday, little bit off subject, but just on site yesterday, we're speaking to a very large, 50 guys on site, and we're in there chatting to him about his own tracking of labour and still using paper-based timesheets, and I'm blown away by it. But I can only imagine in your world how difficult that is.
Bizarrely, and this will go against a lot of what you will be promoting, but bizarrely it's actually like email and the digitalisation of construction to a large degree kills, because the systems aren't currently there 100% to manage a lot of the record keeping that we would need in the dispute world. That actually having the old fashioned paper is not the worst thing in the world for me. Like I would much prefer to see the guy coming with the timesheet in a triplicate book, because he has it and it's signed and he has a copy and the other side have signed it. And having that records are vital. There isn't, I haven't come across similar systems in the digitalised world that really deal with that aspect of it. Recording a confirmation of a verbal instruction being given on a site. We have for years had what we call CVI books, confirmation of verbal instruction books, triplicate books. Someone asks you to do something, you take out the book, you write down what they're asked you to do, you get them to sign it. That's a record of that verbal instruction. There isn't a digitalised version of that. There should be.
There definitely should
and
be.
The minute you sign it, it's a copy sent to everyone's emails. There should be, but it's not there. And record keeping with emails and stuff is difficult. It's very difficult. Like back in the M50 days, like if we were writing a letter, we didn't have the internet on the M50 in the late 90s, which is a bizarre statement to make. But it didn't. It was there, but it was dial-up. We didn't use email on our jobs. So if you were writing a letter to your opposing party, that letter was printed, signed, it was given a reference number. The reference number was handwritten into a book. But you could always find, like you could do a search for letters relating to a topic and you found it very quickly. Try and do that with email and the thousands of emails that go over and back, because we've no system of like digitalising emails. Now the legal world do, and there is some good library systems there where you can put stuff into the right filing cabinet in theory. But
in our world, the way we sort of deal with that is we create digital documents whereby so let's say digital document being purchase order, digital document being a delivery docket, delivery digital document being an invoice, and we categorise them into against jobs. Well, first of all you have your overall folder, and then you'll also have them against jobs. So if you had a dispute against a phase or a job, you could actually log in and say, well, here's all the purchase orders and and we can export that. So we do go there, but we don't go there for dispute reasons.
And I think the evolution of that into confirmation of verbal instructions with people on an iPad, record keeping on day work. So like you have systems there to manage hours, but getting down to the detail of a guy spent 3 hours on this day with a Kango hammer and 250 lengths of timber, doing this specific item which is related to that confirmation of verbal instruction. We haven't got there yet. And when we get there, that'll be brilliant, because it'll have that record. But for the time being, we need to do that in the old-fashioned triplicate book. And so at least I think kudos to your client yesterday who at least was doing those records, because the amount of people who aren't, and then they come to someone like me with a dispute and they have no records, and that's the difficulty. You can't. We're not magicians. With the best will in the world. So records are vital, and your business will be helping. Certainly the quantum aspect of that. But it's the whole instruction and the initial bit as how this thing came about in the first place is the bit I think where most of us fall down.
And is that the difference? You mentioned there that there is similarities of adjudication and similarities to the Construction Contracts Act in different sectors. Is that the difference is in the level of detail that we need to go for a dispute?
See, adjudication, so we have we have had dispute systems in Ireland in construction. We've had conciliation and arbitration and mediation for many years. Adjudication is a process driven, okay? So like we've adjudication, like many people will have heard obviously the PRTB or now the RTB. If you have a dispute over a tenancy in Ireland, and this goes back to their act came in I think in the 90s or maybe was it 2004, so it's in a long time. They have two dispute mechanisms. The first dispute mechanism is mediation, but the second is adjudication. So it's adjudication is their dispute system between landlords and tenants, okay? Some people might not know that, but that's in theory. They also have a tribunal system, but at the core of that is an adjudication system, okay? Right. And again, that can be record driven. And again, you may have hearings, you may not have hearings. The WRC, which lots of people will have heard of in the employment space, again, they have a conciliation and an adjudication system. And again, it's about resolving disputes, okay? So there's the adjudication model. What makes the construction industry different, I suppose, is that it only resolves payment disputes. So the legislation is solely for payment disputes. So you can have disputes on time that may not be related to payment. Now, it's pretty sure most people will try and turn any dispute into a payment dispute, and you possibly can. But in the UK legislation, they can adjudicate on anything. So if the disagreement is over time, not necessarily money or quality, they can adjudicate that. In Ireland, we can only adjudicate payment disputes. So that makes the difference.
And you touched on this earlier on, but in terms of the fees, so for me to go and raise a dispute, you're saying that there's no fee at that stage?
There's no fee for you to get someone appointed. No.
Where do the fees come in?
Well, the fees is twofold, right? So the way the fees, because they try and make this system that, it's representing the small guy and the big guy. So they try to come up with a system that this can work. Okay. So whatever fees you incur on your side of the table. So you're a small subby. You don't know how to do this yourself. Now this system is a learned system. So I would expect over time the bigger contractors will do these themselves. They will not need legal advice, because they will understand the process. Lots of companies will automatically go to solicitors with this, or come to someone like me. But in theory, you can do this yourself. But let's say you can't, and you need to employ somebody like me. Whatever cost I run up with you, people like me will charge on an hourly basis. We don't know it's a small case, big case. So whatever that cost is, you will never get that money back. Okay? But the same goes for your opposing party, your main contractor, let's say, who may appoint one of the top 10 legal practices and they might be charging 500 or 600 quid an hour. They could run up a 50 grand legal bill. You're never on the can for that either. So that's not up for discussion. They incur that cost. You incur yours. The only cost that's up for grabs is the guy in the middle, is the adjudicator. And the adjudicator dictates who pays their fee. Okay, so now again that will be dictated by how much input. They all charge on an hourly basis. There's a lot of talk as to whether we should have low cost models, fixed fees, but there's competition issues with that, and a lot of the institutes have been trying to push that, if you have a dispute under 50 grand there'd be a maximum fee and this type of thing, but they haven't come to fruition. So at the minute you have an hourly fee, and from my experience on most cases they're somewhere between 15, 20, 25 grand.
I was just going to say is there a point where a claim isn't commercially viable?
We run them in our office where we will have a chat with somebody and just kind of sit down with them and kind of say, look, I've ran adjudications for 12 grand. I've won at the minute for 14. My view has always been an access to justice type of thing. So if there's someone who's really been wronged, I will take a view on that and kind of say, look, we can do this, we can limit the inputs we have, and our bill will be limited to a value. Okay, win, lose or draw, we limit it to a value. But the client has to take the risk on the fee. If you have a 14 grand dispute, the likelihood is that won't take 28 days for an adjudicator to work their way through. It won't have 1,000 pages of a referral. It should be relatively minor in nature. So the bill might be 7 or 8 grand. And it's really a gamble, and it is a gamble. you know, that a subcontractor, let's say, may take against the main contractor. But what you'll find in that is that the risk assessment will also have to take place in the main contractor's office as to whether they realistically want to spend money that they can't get back fighting a 14 grand dispute. 14 grand could be £1 million to that subcontractor. It won't feel like £1 million to the main contractor. So the circumstances dictates viability.
Yeah.
You will have subcontractors, and I've had subcontractors sit opposite me and they've simply said, Keith, he says, we're owed 14 grand, we'll prove to you we're owed the 14 grand. If you get the 14 grand, you keep it. But it's a matter of principle that we don't want it in the main contractor's pocket, or we don't want it in the client's pocket. Because I represent main contractors and subcontractors and clients, so we represent everybody. And but like, now I try and talk people off that cliff, because that's like, principles only get, you know, principles make me rich. They don't make anyone else. They make the legal world rich. Like, this isn't about, it's about kind of trying to foster relationships that work. Yeah. You know, live and learn, drawing the line in the sand. You know, you don't want to be getting into the trench on like this. Like, this doesn't do people's stress levels any better. You know, things like that. So you kind of, you know.
Like, in your opinion, then, has this been? I mean, it's been around since what, 2013. Has it been successful?
Well, it took a long time for it to come in. It originally came in as a bill in 2010. It was enacted in 2013, but it didn't commence until July 2016. So it actually, even though it's the Construction Contracts Act 2013, it wasn't enacted. It didn't commence. Sorry, it was enacted, but it didn't commence until any project entered into after the 25th of July 2016. Okay. So when people woke up in the morning of the 26th of July 2016, this is now in play for them on any job they entered after that. It took a long time. Like, I did the first application to the panel for an adjudicator, and we did that in November 2017. And we were the first, like, you know, and I have the letter on the wall at number one. And so I was the first person to do it. Now, there had been, on our system, you have the panel. Yeah. But then you can do it off panel. So even though you're not on the panel, you could sit as an adjudicator if the two parties agree. So there was cases anecdotally going on before the first panel one ever. You know, but the panel has been slow. Like, the first year, like, literally there was one, and then the first year I think there was 4 or 5. Second year I think it went up to somewhere like 18 or 19, and then the third year, which our adjudication year runs July to July, because it commenced in July, and I think there was close on 30 or something in the third year. Still very small. It's small. Like, my office, like, we use it on a daily basis. So like the I think what the Act, the simplistic way for me to say the Act works is because what the Act does is it takes the dispute out of the cabin. Yeah. And what I mean by that is it takes the dispute away from the site. So a lot of these disputes happen because of egos and communication between somebody and somebody. And that's at site level. And when kind of egos and everything kick in, you know, you end up with disputes that should never have happened. And a lot of them can be traced back to that, or a lack of communication. Yeah. And that's at site level. The threat of this legislation means that, like, it takes it out of the cabin quite quickly, and it can take it to a director level or whatever. And you find a lot of cases that they settle without you ever needing the adjudicator. Yeah. And like, last year we did 15 of these. So we issued 15 notices. The year before we issued 17. Okay. Already this year I issued 2 on Friday of last week. Like, I think we're on 5 or 6 this year already. Now, it is definitely growing, and it is being used more, and more people are being known about it. But like, this year we've issued, as I said, 5 or 6. All of them have settled. I think I've the 2 on Friday are outstanding. Yeah. You know, I've another one on draft, but the ones that have kind of been issued for any period of time within the 5 days have been settled. And I think the stats for 2 years ago, I think, were the most evident to me why this Act works. And we issued 17 notices. And remember that you issue a notice and you can't do anything for 5 days. 11 of them settled in that period. Yeah. Out of 17. You know, so that we carried 6 then where we sought appointment on 6 files. And we sought appointment, and another 2 settled just on taking it to that next stage. Because it's about pressure, and you're ramping up the pressure. You're taking control away from the cabin. Yeah. You're going to give it to someone else. So another 2 So out of 17, we had 4 adjudicators who actually had to write a decision. There's no other system available to the industry to resolve, and you're talking about resolving these in the month.
Yeah.
You know, within a month, and there's no other system. And that to me, so it's the threat of what the threat and cost of going to adjudication makes people say, you know what, we need to sit around the table and we need to resolve this, and we don't need it to be going into this system.
Yeah.
And that's why it works. You know,
what's the awareness looking like? I mean, I touched on, I suppose it was nearly 2 years ago when I sat down with you and I didn't know much about this. What's that look like now?
It's poor. It's still poor. Like it would be like if you take the industry, like if 20 to 30% of the industry have ever like done anything relating to the act. So be it, you know, issued a notice or spoke to their opposing party about adjudication, or like I'd say if 20-30% have ever like done anything about the act, I'd say there's probably less than 50% knowledge that the act even exists and what that means. Like what does the Construction Contract Act mean? Like I'd say less than half the industry even know it exists.
Yeah, I'd agree with that.
And I'd say an even smaller proportion of that, as I said, 20-30% have ever like dabbled with it.
Is there a certain type of project that it won't do, or is it just a construction contract act between two businesses that
what it doesn't cover is any project. Obviously the project you have to have entered into a contract after the 26th of July, which is, as time goes on, that becomes less of an issue, but people still come to us today with jobs that would have started before that and are in dispute. We can't help them using the act. You have to use the other systems. But so that's the first thing. The second thing is it only covers contracts with a value greater than 10 grand.
Yeah.
Okay, so that's the second point. So anything with a value less than that isn't covered by the Act at a high level.
Yeah.
There's ways around everything.
Yeah.
And the third bit, which I know a lot of your clients, this would be relevant to them, would be they try to keep Joe Bloggs building his house out of this, okay, because of the administration involved in the system, because the whole payment system is time related, and you can speak with that for hours. But so to do that, they have this 3-pronged approach. So if you tick these 3 boxes, then the Act doesn't apply to you, to your contract. If you don't tick the 3 boxes, it does. Okay, so the 3 boxes were that if you entered into a contract for a dwelling, so that's box number 1. Okay. For a property that's not greater than 200 square meters, so that's box number 2. And where one of the parties to the contract intends living in the dwelling. Now that's not the exact phraseology of the Act, but then the Act doesn't apply. So you enter in, take Cascade, who we know, and give them a plug. They enter into a contract to build a house for somebody, and that house is 150 square meters. And the person they're entering into contract with is going to live in that house. That contract is not covered by the Construction Contracts Act. Okay. But if Cascade, there's an argument over if Cascade are building a garage. Yeah. That's not a dwelling. Mm-hmm. So words come into it. So the garage might be covered by the Construction Contracts Act. But where words get important is, and where the difficulty sometimes with language and acts is, you take those 3 boxes. The subcontractors of that contractor can never tick the last box. Subcontractors will never be contracted to the person intending to live in the dwelling. Yeah. They will be contracted to the main contractor.
That's true, yeah.
Therefore, they can never tick the 3 boxes. Therefore, their works, once they're over 10 grand, will always be covered by the Construction Contracts Act, even though the main contractor may have no cover against the client.
Yeah, that's fair.
So there's some kind of problems in the wording of our Act. But so basically, they try to keep that home market out of it. If it's greater than 200 square meters, it falls under the Act. Yeah. If the person is a developer and don't intend to live in the house, it falls under the Act. It becomes a commercial project.
So once you're over 10 grand, once you're over the 200 squares, and then once you're dealing with the contractor and not the
you're covered.
The client.
And to be fair, once it's over 10 grand, once the property is greater than 200 square meters, you're covered irrespective who you're contracting with.
Yeah.
And that's really the only exclusions. Like things like plant hire, like there is other exclusions. Like if you hire plant but don't have a driver. You're not given a driver with the machine. That's not covered. And there's various things like that. But in the main, if you're in a commercial context specifically, this is covered.
It's definitely something that I always said it's a cancer in this industry that main contractors are able to and have the power to send smaller guys out of business.
It is, I suppose, and to stick up for the main contractors, and look, and there's no vested interest in me, given that I represent everybody. But main contractors find themselves in this scenario on a regular basis. I suppose the difficulty for them is that the clients available to main contractors are a much smaller group than the clients available to subcontractors. So subcontractors, it'll be easier for a subcontractor to instigate adjudication against a main contractor than it ever will for a main contractor to instigate it against their client.
Yeah.
And that's just a reality. So main contractors, a lot of them will be using conciliation and arbitration type schemes and mediation to resolve their disputes a lot quicker than they will ever buy into adjudication.
Yeah.
Okay. Because it's more aggressive and it's not as friendly. So to defend them slightly, yes, we have a blockage. And the Act didn't help that. It introduced it separated main contractors and subcontractors in our Act. We were the only country in the world to do it. Where in the UK legislation, it's a default 30-day payment cycle. Okay, and subbies and main contractors can agree to different. So they can agree to 90, and then that supersedes the 30. Okay, so you start with 30, but if you agree to 90, you agree to 90 in terms of your payment cycle. And you have to stick to 90, okay, which is not great, and that's how a lot of contractors with Carillion and that the payment cycles of 120 days and stuff. So when they looked at the Irish legislation, subcontractors cannot agree to more than 30 in Ireland. You can, but you can always fall back to the 30. It's law of the land. You can sign a contract for 40, 50, 60. It's not worth the paper it's written on. You can fall back and seek payment every 30.
Okay.
Right?
Didn't know that one.
But they only did that for subcontractors.
Right.
Main contractors, they did the UK model where it's a default 30, but if you agree something else, then that supersedes the 30. And in a country where we have a huge amount of our clients are foreign direct investment and the government and different things like that, they will regularly turn around to main contractors and seek 90, 120 day payment terms.
Yeah.
And the main contract community haven't really a way around that. They either want to do the job or they don't. So they could be on a 120 day payment cycle and the subcontractors are on 30.
Right.
And there's an inequity there.
Yeah.
So whereas a subcontractor may give out about the fact that they're having a fight with the main contractor, the reason for that is because our system has even though we've brought in this legislation to fix this problem, you've now allowed a funnel that main contractor doesn't put any money in the funnel for 120 days, and yet everyone has to draw out that every 30.
Yeah.
So it's an industry-wide issue.
Yeah.
It's not just a subby main contract. I represent main contractors. They have as many, if not, and are spending enormous amounts of money resolving disputes with the government, with the HSE. With probably more the government than private clients, to be fair.
Yeah.
So
and I spent a bit of time at UK Construction Week in October last, and the topic of the couple of days was all around this.
Yeah.
These payments, the acts, how are we going to fix it? So their system is far from flawless.
They've had their system since 1996. They're streams ahead of us. They had it in 96, they updated in 2009. They're talking about updating it again. Ours only came in a few years ago. So they have huge case law, and their system is like a well-oiled machine.
Yeah.
Everybody uses it. They have I would say 100% visibility on their act. If you're not doing what the Act says over there's something wrong with you. It's expected. Main contractors expect you as a subcontractor to do it properly. So they've developed a long way, and we can only hope that we get to that level, of visibility, because the more people that know about this, the less disputes we will have. Because
what can we do, Keith? What can we do as an industry to get it out there, so more people understand the protection they have, which is the key.
We need the supply chain. And it starts at the bottom, because the quicker the bottom, if you work from the bottom up, this will never be something that works from the top down.
No, I wouldn't imagine.
You need the bottom up to basically move to a more commercial awareness. You take systems like your own, you know, like you're going into a marketplace where, you know, and you'll see this right away, it's like people have no systems.
Yep.
So you're introducing systems. So it's the same. Like you could nearly align visibility of your product with and what you have to do to get your product out there with visibility on the Construction Contract Act.
Yeah.
It's you know, the need for the supply chain to educate themselves in business.
Yeah.
Full stop.
Yeah.
You know, and this is core to that. You know, systems like your own, systems like, you know, how you manage payment processes, how you manage your disputes, how you manage paperwork, record keeping. Like they're all fundamentals, and I think, you know, as people develop education, you know, a lot of our industry left school, have trades, done apprenticeships, but they're not taught this stuff. They're not taught running a business.
Mm-hmm.
And some of the most, like we have some brilliant tradesmen in this country.
Yeah.
We have some, like some of our buildings, some of the work is outstanding. But a lot of the time it's been done by really bad business people.
Yeah.
You know, I would have them build my house, but they're not making any money doing it. You know, they're not running a business. They're brilliant at what they do. The product is superb, and they just need to bring them two together. And we need to introduce, like to me, it's nearly a necessity that builders need to educate to be builders, and that means more than build.
Is that something that needs to be come down from government level, then back down to, as you say, from the bottom up? But is that something that needs to be pushed down?
Yeah, like the likes of the Siri register and things like that are a start. But you know what we need to do is move to a model and ensure that if this comes in as a statutory thing, that it's focused. It's not just a money generation, another list. It's not just, you know, it's not just regulation by list. You know, we need to drive requirements down that list and down that chute, and it's a good start, because it will give you if everyone has to be on a register, it gives you the list of people that you then need to focus training. You know, products like yours and others and BIM, and you know, there's so much movement in construction. The dispute, record keeping, commercialising your business, running your business properly, not losing money, margin, what that means, retentions. Like there are so many things you need to learn. Contracts, like getting a contract, putting it in the bottom of the filing cabinet and kicking the filing cabinet closed and thinking it goes away. You know, what you're signing up to. You know, getting a 90-page document from a main contractor, just signing your name and sending it back. Like the stuff that does be in there, like so all of this stuff, that bucket of the stuff that goes on outside if you lay in the blocks, is the stuff that, you know, we need to come up with a way of forcing. Yeah, and
there in fairness, there is, if you go looking deep enough, there is stuff out there. Anything that has a chance, as you said it's at the very outset, of keeping people in business and keeping families and food on the table is a good thing. So I believe, and that we'll do anything we can to push this and get it out there. If people did want to contact you directly, Keith, where do they find you?
The easiest, you find me online, I suppose. We have quantisurveyor.ie and also adjudicator.ie, but to be fair, if you Google Keith Kelliher at this stage, generally will pop up somewhere. You know, but easily found on the web. And
are you active on LinkedIn?
Yeah, LinkedIn, Twitter, and I wouldn't say I'm a social media. I do enjoy LinkedIn because I suppose it works and the professional interaction. But I do have Facebook and Twitter, but I wouldn't be as active there. You know. But
Keith, thanks very much for coming in.
Pleasure.
Really appreciate it. Thanks very much.
Not at all.